I'm just going to wait 1 or 2 more minutes. Hi, everyone. I think let's get started and people can still join. I'm Kim Straker, and I wanted to welcome you to our HR Forum event addressing remote workforce issues during COVID and beyond. We know that all of you have grappled with remote workforce issues for the past year, and because it looks like remote work in some form may be here to stay for a while, we wanted to discuss 4 main topics today, which have been a source of many questions. First, my colleague Meredith Berger will discuss which leave laws apply when an employee's office is in one state, but the employee is working from their home, which is in a different state. Next, Mike Loby, who is one of our tax experts, will discuss various tax implications for both employers and employees when there are remote work arrangements involving employers in one state and employees working remotely in another state. Third, our colleague Amanda Williams will discuss whether employers have to reimburse employees for their work from home expenses. And last, I'll address key points to include when drafting or revising your remote work written policy. If you have questions during our discussion, please feel free to send them along in the chat box. I'll monitor that, and each speaker will try to address the questions after their segment. When we pause for questions after each segment, you can also feel free to unmute yourself and just ask your question directly. If we're unable to answer all of your questions, then we'll follow up with you individually by email after the event. We have a PowerPoint here that we've prepared to help you follow along during our presentations. And also we wanted to let you know that we're recording this event so that we can send the recording out to those clients who aren't able to attend here today. I'll be announcing the CLE code later for those of you who want CLE credit. And following the program, you'll receive the CLE form along with our written materials. So with that, I'll turn it over to Meredith to kick it off today.
Thanks, Kim. Morgan, you can go over just to my first slide if you don't mind. Great. So as you can see from our backgrounds, we're all working remotely, which is really appropriate for this presentation today. And what I'm going to talk about, as Kim previewed, is what law applies when employees are working remotely, either based on a change due to COVID or just in general. I think a lot of employers are thinking about making remote work permanent and making that part of their their just normal business going forward. So with that, there are a lot of concerns, especially surrounding sick leave and other kinds of leave laws, as well as accommodation considerations that employers should take note of. I think one thing to highlight, just as an initial point, is that sometimes you don't even know your employees are working remotely from a different state than where their residence is. Kim might have some notes on that when she talks about policies, but that's an important thing to know, is we need to understand where our employees are working from. Luckily, Seyfarth doesn't have an issue for me. I live on Long Island and work in New York, so I don't have an issue there. But some people live in New Jersey and their office is based in New York, and vice versa, and even further. You'll have people working in Florida and beyond, and unfortunately, California for employers is particularly tricky. So with that, I just want to caveat this by saying that this is very fact specific, this analysis, and it really depends on where the employees are working, what the combination of in-person and remote work is, and how permanent the arrangement is. If somebody is on vacation, let's say, or let's just say a temporary arrangement where they're working in a different state for a month or two, the risk is low that of non-compliance with a sick leave law in that particular jurisdiction. When you get to more permanent arrangements, like during the COVID pandemic, which has unfortunately extended now beyond a year for many people, though that is a more long-term fix. I think when we initially shut everything down and everyone started working remotely, there was a thought that, this is only going to last a couple of weeks, a month, and then it just stretched on and on and on. And here we are over a year later. So at this point, employers really should be assessing where are employees working, what laws are we applying for those employees, and what is the mix of in-person versus remote work? If somebody is going into the office with any regularity and working remotely with any regularity, then that should prompt an assessment by you as the company of saying what laws should apply. Do we need to add any addenda to our handbook? Because all of a sudden we have 50 employees who are working remotely from New Jersey, so we need a New Jersey sick leave policy. That's an important consideration. You want to be on top of that kind of thing. And when you do assessments of, a census, a population employee population census, that should be one of the things that you're also counting in that census, is where are remote employees working from, not just what office are they based out of, because of our situation now with COVID. And I wanted to preview for you that California has many different sick leave laws in different jurisdictions. There's a statewide, and then there's all different municipalities. And the way they interplay is very complicated. So I'm not going to get into the specifics here, but just to sort of let you know that it's important to make that assessment and to understand that, if you have an employee who is working, who lives in San Francisco, there are particular laws that could apply to them based on literally their address. So oftentimes the analysis has to go that deep into what county do they live in, what city do they live in. So that is just something to keep in mind if you do have California employees. Can we go to the next slide, please, Morgan? So this is our little hypo here. It's a Star Wars theme. So this company, Rebel Alliance, is headquartered in New Jersey. And in 2019, so this is pre-COVID, Leia commuted every day from her home in New York to Rebel Alliance's headquarters in New Jersey. In this case, I think it's safe to say that New Jersey law applies because she's working in New Jersey. She's not working remotely. She should be, provided New Jersey paid sick leave. She should be provided New Jersey family leave insurance to the extent that, she would qualify for that, of course. And for discrimination or harassment or anything, retaliation claims of that nature, New Jersey law would apply. Remember, just keep in mind to give out those annual notices for your New Jersey employees. And in March 2020, Rebel Alliance directed Leah to work from home in New York due to COVID. So in this situation, here we have an employee who normally works in New Jersey. She's getting her 40 hours of sick leave under New Jersey law, but now she's working from New York. Luckily, in March 2020, the New York State sick leave law was not yet in effect, but New York City was in effect. So at that time, the New Jersey and the New York law pretty much aligned. So in this situation, I would say, looking sort of on a retrospective, looking at it retrospectively, there was minimal risk to the fact that if the company continued to apply New Jersey sick leave law. There are some more expanded reasons for use in New York, but assuming that you, as most employers do, don't necessarily delve too deeply into why employees are using sick leave, as long as it's as long as you're asking for documentation within the restrictions of the law, then you're probably safe. But think about starting September 30th of 2020, when in New York State, employees were entitled to begin to accrue sick leave. So at that point, the red flag should have gone up. Okay, should this employee be accruing at this point? Technically, yes, but it was probably uncertain sort of how long the remote work would continue. You were probably thinking maybe we'll return in January, depending on how things look. So I would think that most employers probably wouldn't have taken any significant action. And it probably would have been a manageable risk not to do so, only because, the New York State sick leave law was not yet in effect. It didn't take effect officially until January for usage purposes. So, really, if you hadn't been tracking accruals, it would probably be okay. However, in January, I would say at that point, you should have assessed, the employer should assess, okay, where are we now? How permanent is the situation? And the employee may have been entitled to some additional sick leave if you are a large employer. As you probably are familiar with, in New York State, it's tiered. So for smaller employers, they are only required to give 5 days, but 40 hours, but larger employers must give 56. So there could have been some, missing benefits that the employee was entitled to there. And then finally, in April 2021, Rebel Alliance, the company, announced that it was going fully remote for all employees. Leah continues to work from home due to COVID. At this point, New York law certainly should apply. If you're a large employer, as a large employer, the employee should be getting 56 hours of sick leave under the state law. So certainly if you're at this point making the decision that some employees will continue to be remote for the time being, this is when you should be assessing whether and what laws should apply based on their remote locations. But again, I want to caveat this with the fact that it's very both time and location specific. So it's an analysis that you want to, really take with some care. I know that it's not something that we can sort of package up and say, here's the guide to how to do this, but this is the kind of analysis that you'll need to undertake. We can go to the next slide, please, Morgan. And to close out here, I just want to keep on your radar that anti-harassment training is still required and important, and accommodation requests must be handled appropriately. And as I mentioned before, notices, make sure you're giving out all your required notices for the various laws that apply in different jurisdictions, and especially getting those out to remote employees one way or the other, whether you mail them in paper, whether you post them on a company intranet, if that's permissible. It usually is, but you just want to make sure that your employees are not missing any of those important notices. And, if anyone has any questions, I'm happy to take them. But, just to sort of sum up here, if we're talking about New York, the important thing to remember is that if you're working physically in New York, employees are covered by the sick leave law for the hours that they're present in New York. So that doesn't particularly jive too well with New Jersey, because New Jersey states that if you perform some work routinely in the state, then you're subject to the sick leave law, and it's not based on a percentage, and so it can't be prorated. So that is the difficulty there with New York and New Jersey in particular, that you could have a situation where somebody is technically subject to both laws. And so in that case, sort of the most conservative approach would be to give them the maximum benefit that they could get, taking both laws into consideration. So looking at whichever is the most employee friendly and then applying that one. But unfortunately, that's not ideal for employers, and it's difficult to administer. But that's just the fact. It just doesn't, when these laws were written and passed, they didn't contemplate people working remotely. They didn't contemplate every scenario. So that's why we have this sort of, puzzle pieces that don't quite fit together.
Thanks, Meredith. One question did come in, and I will read aloud. You mentioned that it depends how much time they spend in New York versus New Jersey. What if they're doing a hybrid where it's really half remote and half in the office?
So as I think I might have answered the question or when I went through my little summary, but under those circumstances, if it's really 50-50, then New York would say they're eligible for sick leave for the time they work in New York. So for 50% of their time, they're eligible for New York State sick leave. So if you're using an accrual basis, then they should accrue 1 hour for every 30 hours worked in New York. And then for the rest of the time, so New Jersey would say that if the employee routinely performs some work in New Jersey and the employee's base of operations is in New Jersey, then New Jersey law applies. So in that situation, you could be saved if your company is based in New York, and then New Jersey law would not necessarily apply. But if your headquarters in New Jersey is in New Jersey, then you could technically be subject to both laws, and then have to essentially make sure that they get whatever they're entitled to under both laws.
Great. And I know, you've focused a lot on paid sick leave because that's, of course, the topic of the day. But what about, does the same analysis follow with paid family leave and unemployment if they get terminated? Do you go through that same type of analysis?
Well, it's different. So everything is different, unfortunately. But so for New York paid family leave, that they have a similar test where they go by how much work is performed in New York and where the employer's base of operations is, or where the work is directed and controlled from. New Jersey, I believe, is the same. So you would have to look at each specific, you would have to look at how much time the employee is working in both states, and where the work is directed or controlled from. You could even add another layer of complication if you have, managers working from different states and the headquarters being in a different state and then the employee being in a different state. It could get your mind could boggle from this. But an unemployment, I believe, is based on where you actually live. But I haven't looked too deeply into that. So feel free to email me, whoever submitted that question.
Great.
Are there any other questions, or should we turn it over to Mike?
At this point, it doesn't seem like anyone else wrote anything in the chat box. So I think we'll turn it over to Mike.
Thanks, Kim, and thanks, Meredith. As Kim mentioned at the beginning, I am a tax attorney at Seyfarth, and I'd like to thank my labor and employment colleagues for inviting me to take a little bit of time today to summarize what is a pretty important issue. It's an issue that has existed in the past, but has really become a big issue in the remote work era. And so what I'm going to do today is try to give you a broad overview of the tax issues that may arise when you start to have your employees work in a state that is different from the state in which they live. So a true work from home or work remotely arrangement. Now, what I'm going to focus on today is the main tax issues that you may encounter as an employer, but there are similar issues, some of which I'll touch on for employees as well. Now, one thing I will say, just as Meredith said earlier, is the analysis here, the decisions, the determinations, they depend largely on the facts and in particular the states. Each of the 50 states has somewhat similar but different tax rules for when you need to withhold as an employer, when you may be subject to tax in a state. And so, this is a broad summary of the issues that could be presented, but you really need to work through these issues on an employee by employee basis. So what types of tax issues do we have? There are two main tax issues that may be presented by having an employee work in a state that's different from the one in which they live. One issue is when does the employer need to withhold, and for what states do they need to withhold? And the other issue is when might an employee working in a state other than the employer's home state, that is the state in which they're based, when might that employee working in a different state cause the employer to have a corporate or other income tax liability? I'm going to start with the withholding question. Now, under normal circumstances, in the pre-COVID world, these rules were in place. Remote works weren't as common as they are now in the COVID world, but they existed, and so there are rules out there that govern the situation. Under normal circumstances, there are two jurisdictions that may have a claim over income taxes on an employee's wages. That is the state in which that employee works and the state in which that employee lives. Now, when you have a simple case like my case, for instance, there isn't really an issue to work with. I live in New York and I work in New York. And so my work state is New York and my residence state is New York. And so New York is the only state that may potentially have a claim to taxes on my wages. And so for my employer, Seyfarth, the only state that they may have to consider withholding in for my wages is New York. But before the pandemic, there were plenty of people, especially in the tri-state area here, who lived in different states than where they worked. So you may have a New York employer, and they may have an employee who lives in New Jersey and commutes every day to work in New York. And in that case, there are two states that may potentially be implicated: New York, that employee's work state, and New Jersey, that employee's residence state. And so the question comes about as the employer: do I need to withhold in New York? Do I need to withhold in New Jersey? Do I need to withhold in both? And the answer is, it depends. The answer is probably in the end going to be that you only need to withhold in New York. I won't get into too much depth on this short presentation on the New York tax rules, but suffice it to say, New York is one of those states that's very aggressive about its taxing, and so it has a rule that more or less says that, you know, every day that you work is treated as a New York day, even if you work from home in New Jersey, except in very rare circumstances. So in that scenario, New York is going to be the primary taxing jurisdiction. They're almost certainly going to tax each workday of that employee's work, whether they work from New York in the office or at home in New Jersey. And so usually that means that the employer only needs to withhold in New York. But there will be in other states that don't involve New York in particular, that answer may be different. And so, you know, for each employee, we really need to look at what is their work state, what is their residence state, and what implications might that have. Now, there's one other aspect that I'll mention here, which is that it may not be the case that an employer is required to withhold for an employee who lives and works in two different states. For instance, if you're a New York employer and all of your operations are in New York and you don't have any operations whatsoever in, say, Alaska, the fact that you have an employee who's living in Alaska and, let's say, commuting occasionally to New York or working occasionally in New York does not necessarily mean that you as an employer need to withhold Alaska wages. If you don't have any connection or what we call nexus to Alaska, then you may not be required to withhold Alaska wages for that employee. Again, that's a very state-specific analysis, and we could get into it. And we could have an hour-long call on that issue alone. So I'll just suffice it to say that it's a state-by-state analysis. Next slide. Now, the second issue that comes up is when I have employees working in a state other than my operation state, do I now have a corporate or a company level tax? So again, taking the individual company whose full operations are generally in New York, all of my employees usually work in New York. If I have an employee who is remotely working in Maryland, does that employee's presence in Maryland working from home mean that I now have a, quote, presence, or in tax terms, nexus to Maryland, so that Maryland could assert a tax against me, the employer? And it's a very similar analysis to the one I mentioned before. There's a series of rules called the nexus rules that determine whether or not that employee's presence in Maryland could cause you to have a nexus in Maryland so that Maryland could assert a tax. And it's very state specific. Each state has its own rules on what activities may constitute nexus. But it is an issue that could arise. Now, how has COVID impacted the analysis? The short answer is not as much as we would have hoped. when the stay-at-home orders came out, most employers were in a situation where they needed to shutter their office. So if you're an employer in New York, you may have had to shut down your office in New York, and you may have had to tell your employees that they all need to work from home in whatever state they may live. And you would expect that the various states would come together and say, well, since we're forcing you to tell your employees to go work in New Jersey and Connecticut and Massachusetts, we're not going to punish you as a result of that. We're not going to require that you withhold extra wages in Connecticut just because your employee is forced to work from Connecticut, or we're not going to assert a corporate income tax against you just because you have an employee now working in Connecticut. Unfortunately, only about a third of the states came out with guidance on how COVID will impact the rules that I had described, both the withholding rules and the corporate income tax, if you want to call it rules, the business income tax rules. And many, not all of them, many of that third were helpful. Many of the rules guidance that came out said, if you have an employee who is temporarily working in Connecticut as a result of the shutdown orders, then we're not going to require you to withhold in Connecticut as a result of that work from home arrangement. And we're not going to assert that you owe a business income tax in Connecticut just because of that remote arrangement. But most states, about 2/3, didn't say anything at all. And the states that did something usually have a very limited relief. Next slide. The states that did actually say something usually said that this is going to exist, this relief is going to exist only so long as the shutdown orders stay in place or for a certain period thereafter. And so at the end of the day, we're in a position where we expect over time, especially as the shutdown orders are slowly dissipated, we'll have to return to the normal rules. And for those states that have said nothing at all, we expect that we're still in the normal rules. So the COVID relief has been somewhat limited, and it's certainly temporary. And frankly, we don't really expect that the relief is going to turn into anything permanent. You would think that perhaps the states would evolve with the changing times. There's a greater push on a countrywide basis to move to more remote or more remote friendly workforce. But one thing I'll say is that the states, and especially states like New York, they rely heavily on income tax revenue to support their expenditures. And so they tend to be very, very aggressive about asserting tax liabilities, both over individuals and over companies. And so it seems unlikely that they will change their rules in a way that will be a little bit more friendly to the taxpayer, a little bit more supportive of remote work. And I'll give an example. The last segment I have here is just 2 state examples. The first is New York. As I said, New York has a rule that we call the convenience of the employer rule. And it more or less says that if you have an employee who's assigned to work in New York and is an out-of-state resident, and that employee spends even one day physically working in New York, then New York will treat every workday of that employee as a New York workday, unless the employee is working from home for the convenience of the employer rather than the employee. It's a bit of a mouthful, but what it boils down to is, except in very exceptional circumstances, New York is going to treat your work from home arrangement as being a New York workday, as if you'd been in the office the whole time. There are some exceptions, but that's generally the way that it works. And New York had a considerable fight with Connecticut over the years about this. Connecticut had a lot of residents who worked their way into New York, and New York took the position that if an employee worked from home 30 days during the year and otherwise worked in New York the entire time, 100%, including those 30 days spent working from home in Connecticut, were subject to New York tax. Connecticut took the position that those 30 days were subject to Connecticut tax, which was a somewhat reasonable position. New York ended up winning, and those employees who worked from home from Connecticut during those 30 days were actually subject to double tax. They were taxed on that in New York, and they were taxed on that in Connecticut. And it led to litigation between the two states. New York ultimately won, Connecticut gave in, and they more or less, Connecticut backed down and said, fine, we won't tax those 30 days. And it ended up being New York only. And New York has come out and said, even though we are telling you, New York employer, that your Connecticut employees must work from home in Connecticut because of during the COVID shutdown, we are not going to give you any relief. Those work from home days in Connecticut are treated as New York days. So it has led to litigation in the past. I wouldn't be surprised if it does again. Similarly, Massachusetts, another jurisdiction that tends to be heavy on taxation, has come out with a rule that has said more or less, if you're, for instance, a New Hampshire employee living in New Hampshire, and during the pre-COVID period, you commuted into Boston every day for work. And now during the COVID shutdown, you're working from home in New Hampshire. Most states that came out with relief said, don't worry, we're not going to tax you in Massachusetts because you're working 100%, from home in New Hampshire. Well, Massachusetts said quite the opposite. They said, we're going to tax you in Massachusetts as if you were coming into the office every day. And New Hampshire was not very pleased about that. So they filed a lawsuit against Massachusetts in the Supreme Court, and it's pending in the Supreme Court. So the Supreme Court's going to be deciding whether or not Massachusetts rule taxing those employees is constitutional. And so these are big issues. They're issues that are going to be presented quite a bit in the future. And I don't visualize the end result being one that is favorable to remote work arrangements, at least not in the short term. I'll leave at least some time for questions. I think I've seen, Kim, a few that have come in.
Great, thanks, Mike. Yes, a bunch of questions have come in. You did talk about states, one state versus the next, but what about, are there differences for New York City? If an employee's office is in New York City, but they've been working remotely from Long Island, is there a city tax issue that would come into play?
There is, Kim, yes. Actually, New York City almost inevitably follows the New York rule. New York City has a tendency to just simply follow the New York rule on everything. New York City does have its own discrete income tax. So there is, if you're like me and you live in the city and you work in the city, you pay a city tax and you also pay a state tax. And they generally follow each other. New York City follows the state. But if you were coming into the city and you were working every day in the city and now you're in Long Island, it's based on the relief, or at least the guidance that we've received from New York so far, I would expect that not much has changed in the way that you were taxed before COVID and the way that you are taxed now, because New York and New York City have not been very friendly to COVID relief.
Okay. This next question I think you covered, but just for clarity, purposes, I'll just ask it. If you know, a New York office has been closed and an employee has worked in Florida for several months, but now the employee is coming back to New York. Just to clarify, would it be New York state taxes that should be coming out of their paycheck still, even while?
That's right. The way that New York runs things, it's more or less most of the time the answer is going to be New York taxes 100% of the wages.
Right.
It's one of those states that's very aggressive, and you would really have to set up. There is a rule that allows you to set up a very specific home office that can qualify and get you out of the New York wages, but the rule is so thin and narrow that it's very difficult for almost any employee to fit within that box.
Wow. Wow. Okay. Does it make any difference if an employee was hired during COVID and they were never working in New York, but only working remotely, let's say in New Jersey? But the intention is that when the offices reopens, they will come back to New York. But what if they never stepped foot physically in New York and have always been working remotely in New Jersey, but for a New York-based company?
Well, the short answer is that it's a tax year question. So for instance, let's take 2021. If an employee was hired in March, they live in New Jersey, it's a New York employer. They were hired in March, and the expectation is that that employee is not going to set foot in New York during 2021. Then the convenience of the employer rule doesn't apply, which means that employee does not have New York source wages, and that employee won't be subject to tax in New York. Now, it's really contingent on that employee not setting foot in New York, at least in a work capacity. And so if November rolls around and that employee comes back into work in the New York office, then all of a sudden in 2021, that employee has got at least one day working in New York. They're now subject to the convenience of the employer rule, and they may very well be subject for the full year. So it can become very complicated. And so maybe it makes sense in that scenario to keep the employee remote through the end of the year. And one thing I will say, I won't overly complicate it, but you never know whether New York, in its desperation to grab extra tax revenue, might make the argument that a remote work arrangement, let's say an employer fully located in New York, no offices anywhere outside of New York, has an employee working from home in New Jersey, it's possible that New York may make the argument that that employee is really working from New York, even though they're not physically present in New York. It seems unlikely, but the states have been fighting it over. New York is very aggressive, as I said. They've been involved in suits over this before. So it is possible that they'd make that argument. They may lose that argument, but they may make it, especially during this dry period for New York, where not many people are generating revenue in New York.
Wow, great. Thanks, Mike. This certainly is a very interesting and hot topic. And there are a few more questions, but just in the interest of time and covering the rest of the material, we're going to move on to Amanda. And then if we have time at the end, we can hit a few more of those questions. And if not, then we can follow up with people by email. But thanks.
Sure.
Okay.
Great. Thanks for that, Mike. So I'm going to be talking about reimbursing COVID-19 work from home expenses. You can go to the next slide. And so I plan to summarize some of the really common questions that we've been hearing as far as reimbursement goes, since remote work is much more common now, but it's not like it's an entirely new thing. So there are, in fact, laws that govern it. at both the federal, state, and local level. So generally, the question of whether or not employees have to be reimbursed for their work from home expenses is something that's going to depend on federal, state, and local laws. There is not a federal requirement for reimbursement, but several local entities do require differing degrees of reimbursement. Ultimately, though, even if it's not required by state law, it certainly is entirely permissible and appropriate to reimburse employees for reasonable out-of-pocket work from home expenses. You can go to the next slide. So typically in the pre-COVID era, when we were discussing work from home, or when we were discussing reimbursement, we were looking at things like reimbursing mileage and gas for employees who use their vehicles for both personal and professional usage. Nowadays, we're seeing very different things. So some common expenses are going to include things like internet service, phone service, desks, chairs, etc. Obviously, these are going to be things that vary by industry. But the costs that you're seeing on the slide are frequently reimbursable costs in jurisdictions that have policies for work from home reimbursement. Some less common equipment may be covered, but equipment like that can and should be evaluated on a case-by-case basis. One interesting thing to note is that we are starting to see claims coming in to various courts, especially in places like California, where people are requesting reimbursement for things like utilities and rent. But at this time, we're really just going to kind of have to wait a little bit and see what the courts decide to do with this equipment or with these requests. Next slide. So the FLSA is what's going to govern at a federal level work from home reimbursements. Generally speaking, employers are not required to reimburse their employees for work from home expenses. However, the FLSA requires that employers pay an employee's wages finally and unconditionally, or free and clear. So if an employee is required to return some portion of their wages directly or indirectly, and that puts the employee's hourly rate below the minimum wage, then the employer may be considered to have violated the FLSA's minimum wage requirement. So under this kickback rule, employees cannot be required to directly pay business-related expenses or reimburse their employers for such expenses if doing so would cause their wages to fall below the minimum wage. From a practical perspective, though, remote workers are typically well above the minimum wage, but employers should remain on the lookout for employees that might fall within this category. Next slide. So generally speaking, the tri-state area, New York, New Jersey, Connecticut, follow the federal rule for reimbursing work from home costs. So this means that reimbursement is only required if the employee's work-related expenditures would place their earnings below the minimum wage. New York has no additional laws for work from home reimbursement. However, New Jersey, while they do not require separate reimbursement, the New Jersey Department of Labor will consider the reimbursement of work from home expenses a fringe benefit. And so this means that an employer and an employee, they may contract to the terms of employment, and that might include a reimbursement policy for work from home expenses. If that is the case, the New Jersey Department of Labor will then enforce the employer's agreed upon obligation to reimburse their employees for those work from home expenses pursuant to the employment agreement. Connecticut takes a pretty similar approach as well. Next slide. So as you guys can see on the slide, there are several jurisdictions that have some version of a work from home reimbursement law. So California, Iowa, Illinois, et cetera. These laws, they tend to vary pretty greatly. So for example, California, which we're going to discuss in some more detail, and Illinois have fairly strict laws governing the reimbursement of work from home expenses. but some jurisdictions either make it unclear what should or should not be reimbursed, or they permit employees to contract away the right to reimbursement. Next slide. So California is, I guess, unsurprisingly, has quite a few requirements for reimbursing work from home expenses. Under California's Labor Code, Section 2802, employers are required to reimburse employees for all expenditures necessarily incurred by the employee in direct discharge of their duties for their employer. Interestingly, these expenses can include costs where the employee has incurred no additional expense. So, for example, in California, if an employee is required to use their personal cell phone for business purposes, the employer must reimburse the employee. This is true even if the business use of the personal cell phone doesn't cause the employee to incur an increased expense. So if, for example, an employee already has an unlimited data plan or an unlimited minutes plan, California still requires reimbursement for that plan. Unfortunately, the courts haven't been incredibly clear as to how much an employer is required to reimburse of costs like this, but they've simply said that it is simply a quote unquote reasonable amount. There isn't really anything that would suggest, however, that an employer is required to pay 100% of those costs. So this is something that's going to need to be evaluated on a case-by-case basis to assess how frequently this person is going to be using their personal device for work purposes. And I think it is an important thing to highlight that California's expense reimbursement law only applies to expenses that are necessarily incurred as a direct consequence of the job. So this means that if an employee is incurring expenses that are not necessary, they may not need to be reimbursed. So this raises the question of reimbursement when work from home is no longer mandatory but optional. So when work from home becomes optional, there certainly is a very good argument that the employee's remote work expenses are not necessary and don't need to be reimbursed, particularly because employees are now free to report to work and avoid any of those expenses. But this is definitely kind of an evolving area of law and something that we're going to be keeping an eye on. Next slide. So it's entirely fine and up to you if you want to create a work from home policy, even if you're not legally obligated to do so. Our general sense is that most employers are just reimbursing in California and Illinois, so states that have really stringent laws, and they're not doing so in other jurisdictions. But it's entirely permissible if you have offices in multiple states or jurisdictions to simply create a blanket policy that follows the most restrictive laws, or create more targeted policies for your individual offices. Some considerations are going to be that work from home policies should be clearly and concisely written and easily understood by both the employer and the employee. They should comport with any federal or applicable state or local laws, especially local laws, something to keep in mind. Certain places, so for example, Seattle has its own separate reimbursement law, and that's separate from Washington State. And then something to consider as well is whether or not reimbursement is going to be something that occurs on a case-by-case basis or will take a more regular form. So this might mean that for things that are individual purchases, so like a desk, a chair, that's something that might be appropriate for case-by-case reimbursement. However, if you know that there are certain reoccurring costs, cell phone bills, et cetera, that are pretty much set, it's entirely permissible to craft a policy saying what of that will be reimbursed and not require individuals to resubmit this information every month or every time they incur the expense. A well-written policy is going to include a clear explanation of what the policy covers, instructions for how employees should submit these requests, how and when these reimbursements will be provided, and ideally dates by which requests for reimbursement should be submitted. Next slide. So ultimately, just to kind of wrap it all up, many states follow the federal standard for reimbursing work from home expenses. So it's important to check local guidance to assess the requirements for your relevant jurisdiction. But from a federal perspective, at least, as long as you don't have employees who are at or near the minimum wage, work from home expenses likely won't be needed to be reimbursed at the federal level. If you conduct businesses in multiple states, be sure that the policies that you create for your individual offices comport with local rules and restrictions, unless you choose to create a blanket policy that covers the most restrictive area. And then many courts, something to consider if you do decide to voluntarily prepare a work from home reimbursement policy, is that many courts will enforce employment agreements that include a reimbursement policy, even if that jurisdiction doesn't necessarily require such reimbursement. And with that, I guess, Kim, I'll ask if we have any questions. Yeah.
Great, thanks, Amanda. You know what? In the interest of time, I'm just going to go ahead to my portion.
Yeah, of course.
And that we can answer offline. So thanks.
Sounds good.
Great. I know that we are running a little bit behind schedule. If anyone needs to drop off, of course, feel free to do so. And we will be following up with written materials. But I do want to highlight some important points to include in your written remote work policy. Next slide, please. Great. So the first thing you want to do is set out some guidelines. You want to prevent abuse. So, if you don't want your employees working anywhere, then you have to, in your policy, establish that they must have an office, play at home. If you don't want them working from the beach, or you don't want them, out and about taking calls on the go, you need to put some guidance in your policy about that. You also want to make sure, if you want them to be available during regular business hours, that's something that should go in your policy. Some people may think that remote work means flexible hours. If you don't want it to mean that, then you need to, put clear guidance in your policy. You may want to specify that they have a certain kind of internet access or certain kind of, usage capabilities with appropriate speed. You also may want to specify that remote work arrangements are not intended as a substitute for childcare, that they shouldn't be used as, supplemental vacation. Another important point that you may want to put in the guidelines is that permission to work remotely may be discontinued or modified at any time. So you may want to reserve the right in your policy to, discontinue the ability to work remotely with or without notice. Obviously advance notice is always better to accommodate commuting, childcare, or other challenges, but you may want to state that in certain limited circumstances, limited to no notice may be warranted. Next slide, please. So also application of all company policies and standards of conduct. So you do want to make sure that your employees who are working remotely know that just because they're working remotely doesn't mean that they're not still subject to all of the company's policies and procedures. Sometimes people tend to communicate a little bit more casually if they're sitting in sweatpants, at home, but you want to remind them that your policy prohibiting discrimination and harassment still applies even when they're working remotely. The next point to highlight would be accurate record keeping. You want to make sure that your policy states, especially if you have a large non-exempt workforce, you want to make sure that you remind those non-exempts to accurately record all of their working time. not to ever work off the clock, which would be, working unrecorded time. That they should still follow their meal breaks, and that they shouldn't work overtime unless they get advance approval, if that happens to be your policy. Whatever your policy is governing overtime, you should make sure that you put those kinds of guidelines in your remote work policy. And Amanda covered reimbursement of business expenses. I have that in here. That can go, whatever your policy may be, it can go in your remote work policy. Then, just a reminder about potential workers' comp coverage. You will want to state in your remote work policy that employees should notify their supervisor if any kind of situation or circumstance arises that affects their health or safety or welfare. If they suffer any kind of accident or injury, even while working remotely, it could potentially be covered, depending on the parameters of your policy. Next slide, please. Also, another topic to cover would be the importance of information security. So you want to decide what parameters you're going to set around documents. Can they be taken? Can physical documents be taken home? Is that okay? Do you want your employees to be able to work on or edit documents outside of your approved network? Is it okay if, they send it to a home email address and work from home? If that's not okay, you want to put that guidance in your remote work policy. Make sure that all company equipment is protected from damage or theft or misuse. You don't want, a lot of people working from home have dogs, any kind of pets or children. You want to make sure that any company equipment is, kept out of reach and kept safe. Also, upon termination of employment, you want to make sure that you state that employees have to promptly return any company property, and put a procedure in place, as to how you're going to do that, because it's not always easy to retrieve company property for employees that are remotely working out of state. Then the next slide, please. Great. Then the last topic that I just wanted to highlight is the impact of relocation. You heard from Meredith and Mike all of the issues that arise with relocation, whether they're tax implications or benefits and leave laws that could apply. So you want to have in your remote work policy guidance about relocation. You want any employees to have to request any kind of relocation. You don't want employees to just, without you knowing, just go work in Florida for 4 months, because that could raise all sorts of tax and benefit issues. So you want, maybe to put into place prior approval or different kinds of notification requirements. Also, it's a good idea to just put in your policy that the onus is on the employee versus the employer to determine any kind of tax implications, and that employees are encouraged to consult a qualified tax professional to discuss any kind of income tax implications if they do decide to relocate. So I know I sped through that. I wanted to make sure that we covered it. And that is all I have on highlights to include in your remote work policy. But if anyone has questions now, we can stay online for a few minutes. And of course, noting that anyone can feel free to drop off. Let's see.
Hey, Kim, can you announce the CLE code, or do you want me to announce it?
Yes, I'm sorry about that. Absolutely. The CLE code is SS, like Seyfarth Shaw, 2293. And I'll say it again, SS 2293. And I saw a question came in about, do you get overtime pay when working from home? Yes, absolutely. Overtime pay you would get if you're working more than 40 hours in a week under the FLSA. It doesn't matter if you're working remotely or in the office. So remote work doesn't impact the laws regarding overtime. Let's see. So somebody else asked about sharing some effective strategies for retrieving company equipment from work from home staff who terminate. Sure. I mean, I know some clients have, arranged for FedEx and UPS pickups. They've arranged for personal messengers to go to someone's home to pick up any kind of devices or documents. It obviously depends on how far the person is, but I would say certainly arranging and paying for any kind of pickup and delivery of those items is certainly helpful. And we will definitely circulate this presentation. I saw that a question came in about that. In our thank you email, we will send along this PowerPoint, as well as some helpful other like 1-minute memos and articles that our firm has produced on, remote work issues. And with that, thank you so much, everybody, for joining us here today.
Thanks all.
Thanks.